Welcome back to Ask the Attorney. I'm Susan Tierney. This is Scott Horne. And today we are going to talk about all things probate. So stay tuned. So Scott, we have so much to talk about when it comes to probate issues, and we see this all the time in our investment business, and obviously as a real estate attorney, you see this constantly. And you always say to me, the number one thing is to get all the information up front. So tell us, what information do we need to get up front?
Well, I see so many investors who are so anxious to get a deal done. They don't get the deal done. They simply don't know the questions to ask out there, because so often they're going out and they're dealing with one heir on the property. And there may be 3 or 5 or 10 or who knows how many heirs out there that they're going to need to deal with eventually and put things together. And what they need to do is stop, pull back a little bit, and start asking questions.
Okay.
Let me just tell you a few things that I see that are so common out there. So unfortunately, we guys tend to die first. It's not fair, but it's just life.
That's because you don't take care of yourselves like we women do.
I just think y'all drive us that way more.
Oh, is that it?
But I wouldn't point fingers somewhere. But because of that, they're usually dealing with the mother who may have passed away. And that's great. But what they should do is stop and ask the children, was there a dad who had passed away first? And were they married when they bought the home? Or whatever it might be in that regard. Or had there been a divorce? And just go through and ask the common sense questions to determine those kind of things. Because the question becomes so often, there aren't wills associated with these transactions. We have to relate ourselves to heirship affidavits. Mm-hmm. And of course we can get as much information as possible, because we may wind up not just having to get the mother's information and do her heirship affidavit, we may have to do the father's. We've done some deals just recently. We had to go back as far as 1917, where great-great-grandparents owned the house.
They have records that go back that far?
Well, I mean, the home was owned that far. Yes, they do, in the deed records. But we had to go back because nobody had ever probated anybody's estate for all of these years.
Wow.
It took an enormous amount of time to do this. Mm-hmm. And then, of course, you find situations where you have kids and kids of kids and kids of kids of kids, and it becomes really untenable at some point in time.
So would they start with the question, were you married before?
Yes.
Were there any other marriages in this? And that's where they start, and then they go down the succession of...
You do, and it's just learning how to ask questions, really, and it's getting comfortable asking questions and not being ashamed of it. It is what it is. Mm-hmm. You know, if the mother had passed away, and let's say there were 3 kids, and they are all out there, of course, we're going to get those 3 children under contract in order to have a valid contract. But maybe we got to do the heirship affidavit for the mother. But we need to find out if dad was out there prior to, and was his estate probated. And so often it wasn't. So we wind up having not just moms, but dads. But then there may be other issues that are involved. And this pops up always. The next question I like to tell the investors to ask is well, was mom and dad married once and only once, or did they have prior marriages? Mm-hmm. And so often in today's world, there are prior marriages. Right. And if there's prior marriages, there's a good chance there are prior children. And here, at least in Texas, and I'm not sure if this is the same in all other states, but here in Texas, because we are a community property state, mom and dad would each own half the property. So if the father had passed away and there were children by prior marriages out there, his side, not mom's side, just his side, and were children of the current marriage, the children would inherit half the property and the mother would inherit half the property. Now, when that happens, of course, the problem is we have children that we have to contend with and do deed searches on. Because as soon as the father passed away, title vested in the children's names. And so often they think it went just to mom only. And although mom's living there and taking care of it, they just don't know what they don't know.
Okay, when you say title vested, what does that mean?
That means the ownership goes immediately when dad dies to the children.
Even without a probate or a will?
Yes.
Okay.
A probating the estate can become a conveyance when the estate conveys the property if there's a will.
Okay.
But with heirship affidavits, we're trying to validate and verify the life of the person who passed away, who the heirs were, so that title can then pass to those. There's a chain of title going from, let's say in this case, the father to the children of the mother.
Right. Okay, let me ask if, so the dad was married before and he had a couple kids. What if one of the kids died but has children? Does then it pass down to those kids?
It does. And things have changed in our probate codes over time a little bit. So it depends on when all this happens and occurs. But primarily, let's go back to our example where mother has now passed away, but dad passed away also, prior children. Let's say dad had 3 children by a prior marriage, and maybe they had 2 of the current marriage. So the 5 children would each inherit half the property, or 10% each, and the mom would get half. Now what's fun to do is that the children, so often, they do want mom to get everything. So we can do waivers of interest that would pass the property to mom's name. There used to be a rule here in Texas that you couldn't execute a waiver unless it had to be within 9 months of death. But that has now been done away with, and they can execute it at any point in time now, which is great.
Okay.
Otherwise, we have to get deeds from the children to mom, and the children have lien issues, a judgment lien maybe, because this becomes separate property, and it's not their homestead, so therefore liens can attach. So tax liens, judgment liens, child support liens can attach. And if it does, it becomes an issue and a problem. So the waiver of interest is a great way to get around those liens, because it says if they never owned the property at all. So instead of doing a deed, we can do the waiver and get everything in mom's name, so we can then navigate mom. Or if mom has passed away also, then of course her interest would go to the 2 children between mom and dad. So for instance, if we had 5 children, 3 by a prior marriage, 2 by the current marriage, they would each own 10% and mom would own 50. So when mom passes away, the 2 children with the current marriage would get mom's 50%. So they each would own 35% in that case.
Okay. But wouldn't they get some of dad's too?
No. Well, they got dad's when he passed away. They got his half.
Okay.
They get mom's half when she passes away.
Oh, okay.
So if one of those children had passed away and they had children, well, now we got to stop, do an heirship on that child and go down to those children. And hopefully they're not minors, because minors cannot convey the ownership. And so I know that when I go out on a property call, I know the questions to ask. And I want investors to learn how to stop and start asking questions. Now, we don't want to get off in the weeds too much, because we could go down and down and down and down the chain. Right. And investors don't have enough time to do that most of the time. But you can ask some of the basic questions and get down for 85, 90% of the time, almost all the questions answered the first time out. For things just happen, unfortunately.
Okay, so big questions. Ask, was there a marriage prior to this? And were there any children? What else?
Well, you want to find out as much information as possible. One of the things I see so much of, at least here in the Texas marketplace right now, is a lot of the investors are dealing in some low to moderate income neighborhoods where nothing has been done. There are no wills, there's been no probates or heirship affidavits or anything, and they don't know. And then there are a lot of children who are being born out of wedlock, unfortunately. And even that's the case, and they haven't been necessarily adopted by maybe another family member, they are children of one of the spouses. We have to know all the information, because if we don't get it all right on the heirship affidavits, it could open up the possibility for a lawsuit, because maybe there's a certain interest could pass to those children of unknown heirs. Right. I know that probate lawyers will say probate the estate a lot of times in those cases to help prevent that. The problem with that is sometimes probate in those areas can be expensive and take a long time. We don't have the time. Right. Maybe the house is in a pre-foreclosure mode and we can't wait 6 months or a year because of that. Or whatever the situation might be in order to get it. And so there is sometimes a risk out there. But we're trying to get as accurate of information as possible that's out there.
Okay.
And sometimes you can't get it, or it seems like you're not getting enough info. Our job in the law office, as we're handling this from a title perspective, is to look at information being provided. We also try to ask questions and follow up, just to ensure we're getting as accurate of information as possible for this purpose.
Right. Now, you had an example recently in a closing that you were doing when it came to know that there was another marriage and a younger child in Balk Springs. Tell us about that.
Well, this was a transaction that was, you don't see this too often, but it was a situation where the gentleman bought the home when he was single, and a few years later got married. They were married for 10, 12 years, and the wife died, unfortunately. So now the husband still lives in the home, and many years later decides to go sell it. And here we are today. And from a title perspective, all you find in deed records is the husband is on deed record title, and the mortgage is in his name only. There was never a deed conveyed from husband to wife for maybe a 50% interest.
Right.
And then husband is selling the home. Well, the husband thinks he owns the house. They don't know that they have to do something in order to pass the chain of title, because if you look on the CAD, it shows to be in his name.
Right.
And from a title company perspective, that's all we see too. So if someone doesn't tell us this, we don't know.
Right.
And in this instance, we were asking the questions on the basic affidavits you go through. And the gentleman said, yeah, I was married. And it's like, oh my gosh. In the title world, at least here in Texas, because of those facts, we're going to want to get it cleared up probably and not run the issue that could occur. Well, the problem was in this case, we had 3 children by a different marriage out of state. We had 2 other children here locally, and one was a minor. And having to get deeds from all of these children from out of state or out of the country, and then having to deal with this minor issue, because a minor cannot sell the property. So, one, we're not closing the title company until that minor child turns 18. You can't get
Even
title.
the father can't, is the father, he can't sign for her?
Well, the father, although technically is her guardian, in order for proper document execution, that father has to be appointed the legal guardian of that child.
Even though technically he is the legal guardian, he's the father, he has to be appointed?
You have to have a guardianship so they can execute paperwork on behalf of that child.
Wow.
And so it creates a lot of problems and issues. And of course, all the investors want to do is close the deal and make money and move on. I get it.
Yeah.
And you hate to be the bearer of bad news, but things just happen.
Right. So if that guy would have asked the right question to this gentleman, were you ever married?
Well, it wouldn't have gotten to the closing table
Right.
where the deal just blows up because of that.
Yeah.
And maybe in that time frame, we could have been working and put the deal together to make the deal close quicker. Or at least have opportunities to do that a little bit.
Yeah. Why don't you share with the audience our experience on Cornet and that whole...
Well, again, you know, in a similar scenario where we have a husband and wife who owns a home, and husband dies. Luckily, there had been a divorce a few months before he passed away.
Yes.
And in that divorce decree, the property was conveyed to the wife as per the divorce. The problem is, with so often with family law attorneys, they don't execute a deed from one spouse to the other.
Okay.
Well, the problem is, one spouse is now dead, so we're not getting the deed, right?
Right.
Which means then we gotta get a certified copy of the divorce decree and record that in deed records. And most people don't want to have their dirty laundry aired out in the deed records someplace. But in this scenario, it wasn't an option.
Right.
But we were able to get all of that and then turn around and buy the property from the wife, showing that she had full value of the home in those instances. Now, yeah, there was some other very hairy lien issues on that property we're still dealing with right now. But you just gotta stop and pull back and look at it for a moment and make sure you have the right information, ask the right questions.
Great. So it all starts with getting the information up front, being smart and asking the right questions.
It is. And you know, Susan, just starting to do it and asking questions. And even today, there are still things I don't ask, unfortunately, or I forget to ask. I know the questions, I'm moving too fast sometimes. And as you do this business, you just get better and better at it, and you remember more and more things to ask along the way.
Right. Okay, great. So remember, ask the right questions.
That's it.
Okay, Scott, I got a good one for you.
Okay.
Okay. Mother, father, and daughter all own the house.
Okay.
The daughter lives in the house with her common law husband. They're not married.
Okay.
And they have a daughter, a child together, all living in the house, and the daughter dies. Or the mother dies.
The mother.
Not the young daughter, the daughter of the mother and father, where the daughter's on the deed,
I got it.
dies.
Yeah.
What do you do then?
Well, first off, back up a minute. And you ask yourself, why in the world are all three on the deed, right?
Mm-hmm.
Well, most likely, mom and dad wanted daughter to have the house, but she needed to have them on the loan to qualify for it, so they just did it in that format, is probably what happened, if I had to second guess it. But then they let the daughter, of course, own the home as her home and take care of things that way. So, boyfriend, whatever you want to call this gentleman, lives there, common law husband, we don't know that for a fact, but probably a safe bet, and they have a child. And then the daughter who owns the home passes away, because mom and dad and daughter each own 1/3.
Mm-hmm.
Who owns the daughter's 1/3? And so this comes down to a fact situation, right?
Mm-hmm.
Is the boyfriend a common law husband or not? If he is, then when you do heirship affidavits for the daughter, but I doubt she has a will, he would get her 1/3 ownership in the house.
Okay.
If not, and if the young child is the heir of the daughter who passed away, now before you can do anything, we go out and get a guardianship set up for that young daughter. Now here in Texas, there is a section of the probate code that allows for the sale of property under $100,000 by a minor. And the proceeds from that sale are put into the court registry until that minor turns 18. The question becomes, what's the easiest way of doing all of that? If it was me looking at that a little bit, knowing the time frame and the cost and expense to get a guardianship set up, is it easier to do the heirship affidavits where the boyfriend, common law husband, owns 1/3 and find a way to acquire mom and dad's interest in the property? So you control 2/3 and maybe file a partition action to buy the other third. It's a difficult scenario, and that's a hard deal to do and look at. The key is there a way to help that deal? Because most likely, either mom and dad want to own the whole house as guardians for the minor child,
Right.
but that's going to be really tough to take a minor child away from the father, unless there's a really good reason to do so.
But don't they have to be common law? It has to be 7 years they were together? Can't you go back and show
No.
that? No?
Well, I'm not here to talk about what the rules and regulations are for common law marriage, at least not in Texas, because I don't know what that would be in another state. Here in Texas, it's living together, holding yourself out as being married, and things of that nature. There is no time frame per se for that. But if you do those kind of items and you have a child together, etc., then there's probably a pretty good inference that that's the case. So that's a toss-up. That's a hard decision to make. And it's just like, what could I do? What would be some of my options? And then, of course, the question is, who are you dealing with? Are you dealing with the boyfriend, common law husband, or are you dealing with the mother and father? And what's the situation? And that's a difficult scenario, and that's when you need to have the right resources to go and talk to them and try to help figure out what to do.
Okay. This comes up quite a bit, and it's when do you file a muniment of title? And what is a muniment of title?
So, a muniment of title is just a short circuit to a probate, where all the estate has is the real property, the house in this instance maybe, and all the other debts of the estate have been settled. And you have to have an original will, of course, to do that with.
Right.
And there are situations where it may be easier to file the will as a muniment title, such as maybe the will leaves a property to one particular person or to one child, and maybe it eliminates another child or other people, that if you had done an heirship affidavit, all the children would have gotten it as opposed to one child. That's when it becomes a positive out there. It's a process here that, at least in the Dallas-Fort Worth marketplace, takes about 45 to 60 days to file it and get a court hearing. Once the will is submitted to probate as a muniment title, you record that court order and a copy of the will in the deed records.
Okay.
And that acts to convey the property into the one child's name. So sometimes there is a reason to do that that's out there. I have a situation right now I'm working on where a niece was deeded, was given the property in a will, but the gentleman who passed away had a biological son who was not in the will. And if you do heirship affidavits, the son gets the property, the niece gets nothing. If you follow the will, then the niece gets it, but the son doesn't. And of course, you've got to do this here, at least in the Texas courts, within 4 years of death of the person who owned the property.
Okay. So it's mostly when there's like internal battling over who gets what?
It could be. But usually it's when the property is being given to a particular person or persons, and it may be excluding other heirs in the family for some reason.
But there has to be a will.
Absolutely.
Okay. Does it have to be a recorded will, or can it just be on a napkin?
You just want to really get off the weeds,
I'm
don't
just
you?
curious because.
Well, if you really want to get that far out, the shortest will.
We had that on the Candlewood property where he had it on a piece of paper.
The shortest will ever put out there was Altamont, and it was written, I believe, on a napkin. There was something also way back out in the old law school days where it was actually written on some type of a melon, and it was sufficient. But you don't record wills. You file a will for probate with the probate court. Okay. Recordation of will is ridiculous. It's unneeded. Okay. It doesn't mean anything.
But if you're filing it and it's not notarized or anything, how do you know? How does the courts know it wasn't written up after the fact?
Susan, so this is where you need to take probate 101 because that gets off into probate law. Okay. And I could get into all that.
I'm just curious that, who's to say it wasn't done after they died and one of the kids decided to write it up?
Well, that's why you have a judge, and there are rules and regulations and laws that govern the probate of various types of wills. There is a will that may be signed and may not be notarized. There may be a will that is signed and notarized. There may be a will that's signed, notarized, and has witnesses that we call self-proved. Okay. And all those are handled differently by the probate courts and different rules and regulations in what you need to prove and verify and validate the truth and veracity of the will. Okay, got it. Okay, let's take it back to my law school.
Let's take another turn. And that was a long time ago. Maybe the laws have changed.
Well, thank you. Well, no, they had just created the earth back then is what I'm feeling like.
All right. Okay, we're going to take a 90-degree turn here and talk about affidavits and or memorandums of contracts.
Oh my goodness. Okay.
This could be a long one.
Well, I'll try to keep it short and sweet if I can, but at least you didn't see these things a few years back, and then you start getting into a dog-eat-dog world where a seller literally may sign a contract on Monday morning with investor number one, and Monday afternoon sign another contract with investor two for a little bit higher price, and Monday evening sign a contract with investor three for even higher price. And of course, no one else knows this out there, and these sellers don't know that they can't do that, that when they sign a contract, they're binding themselves to sell to the first person they sign the contract with. And so knowing that, investors trying to protect themselves think that they can take that contract and file a memorandum in deed records. And I know we're going to hold a seminar on this here soon, but basically all a memorandum of contract does is say, hey, there's a contract between me and another seller. But it doesn't create a lien on the property for payoff. It may or may not create a cloud on the property where a title company, who might find that recorded of record if it's filed in the deed records, may be hesitant to close contract 2 or 3 because contract 1 is recorded.
Right.
But could they? I think there is a strong possibility that the title company could close contract 2 or 3 because it doesn't create a lien on the property. What it does is it simply tells the world that you have a contract, and it shows that there could be a breach of contract where investor 1 may wind up having to sue the seller to protect their interests. And so there's real misinformation out in the marketplace about the role and the need for a memorandum and or how it may work. It's not a bad thing necessarily to file of record, but now you have to release it. And a lot of investors think that they can hold a seller hostage and negotiate for another investor hostage, that if the seller wants to accept contract 3 in our example instead of contract 1, investor 1 says, I won't release my contract unless I get paid X dollars. I think that the contract 3 could probably be closed without any issue, leaving investor 1 with nothing more than a breach of contract lawsuit against the seller.
Okay.
Again, some title companies will look at that a little bit differently than others, but I've seen them go both ways.
Okay. Is an affidavit and a memorandum of contract the same thing, or are those two different?
They're very similar. I prefer an affidavit because an affidavit stipulates what the situation is. It's a sworn document. And you know, if the seller is telling you we're not going to sell you the home, maybe it creates an anticipatory breach of contract that might allow that investor to instigate a suit to protect their interests in closing. Now, when you do that, you can protect yourself in that closing, but you actually have to file a lawsuit and what's called a lis pendens against the property so that these other investors can't do it. But I've had a situation where we have a signed contract with the seller and ready to close the very next week, and over the weekend the seller sells to another investor who does not close through title, who writes a check for cash, gets a deed, and the seller moves out of town. What do you do?
Wow. What do?
You just write it up and move on, because otherwise you have to hunt the seller down. They're going to be out of state. You're going to spend tens of thousands of dollars in a lawsuit trying to find them. And you might win the lawsuit, but you may never find the money. And things just happen in our business. It's a shame things happen that way. People don't honor their word, but they do that in real life.
Okay. Let's talk about some owner finance contracts. Do you have to use disclosures when you have an owner finance contract? Can you just use a truck with owner finance addendum, or how does that all play out?
So, here in Texas, there are standardized contracts under the Texas Real Estate Commission. Other states may have their own contracts, but so many investors, and I keep seeing this over and over again, they don't know what to do. They have a contract only. They might have some type of a seller finance disclosure, but there are no other disclosures that are out there. Now, do you have to use the disclosures and those that at least we suggest and recommend? Maybe not. I think you open the door to potential issues because you're failing to get disclosure across between a seller and a buyer, whether it's the investor buying a home from a seller or selling it to a buyer. Now, here in Texas, there are some issues with the what we call the underlying disclosure notice that must be provided by a seller to a buyer when an existing mortgage is being left in place. But do you need to go through all the disclosures that I've put together out there for our clients to provide what I think is a full and complete disclosure to a seller or a buyer of the situation? And the answer is no. Are there risk issues if you don't do that? I think the answer is yes. And it's those risks that we're trying to avoid. And Can you do it? Sure. Will anything come of it? I don't know.
Okay.
But I see so many sellers out there who think that they're getting their house paid off and they realize it's not. That if you don't have things in place evidencing that you never intended to do that and how you're buying the home, could it raise its ugly head somewhere in the road? Yes, and our goal in this business is to prevent these things from happening.
Right. Question, because if you're going to, wouldn't you want all those disclosures if down the road as the investor you're wanting to sell that note?
Well, if we are selling a home to a home buyer, where we're carrying back a note and a deed of trust, yes, I would want to have those disclosures. I would want to have the RMLO underwriting package.
Okay.
I'd want to make this, as I call it, as pretty of a package as possible so a future investor feels comfortable that the buyer had full disclosure, that they were underwritten properly and correctly, and it protects me as the note buyer if I'm going to do that out there.
Okay.
Buying a home, no one cares about it because we're buying the house. No one's going to sell a note like that.
Okay. When you talk about the RMLO and processing a buyer, can you process a buyer who does not have a social security number?
Well, sure you can. Here in Texas, and I'm sure if you get closer to the border, you find a lot of that kind of stuff. And what I always try to tell investors, again, I know we've talked about this in many of our videos out there, is first and foremost, we want to ensure that our buyer has full and complete disclosure of what's going on. And we don't want to look as if we're taking advantage of a buyer, simply getting their down payment and selling a home to somebody who has no visible means of income whatsoever.
Right.
And so we pull back, and I like to look at the Dodd-Frank Act and what it says, and where it says we must consider and verify information provided to us by a borrower. So I want the borrowers, even if they don't have a social, fill out the application and give it to me. Tell me what it is you make, because now you're giving me your financial information. Do you have tax returns? Yes. No. Who knows? If they don't have them, does it mean you can't do it? No. We're not a traditional mortgage company who has to have those kind of things. We can garner information such as utility bills from maybe the rental property. We can check the rental out. We can have their various employers, maybe they're paid in cash by yard care, cleaning care, construction, whatever it might be, and they can simply sign a document that verifies what they make also. I like to have the borrower actually execute some type of a letter affirming to us what they make, that they understand what the monthly payments are, that they can afford this. So now they're giving me all this information for my consideration and verification. I don't think Dodd-Frank says we have to go out there and verify everything is 110% true, and if not, we call the buyers, liars, right? It doesn't say that. And there has to be some point where you trust the buyers that the information they provide you is true and correct. Why else would they give you a large down payment knowing that they couldn't afford the home and they could lose it?
Right.
Most people aren't going to do that, so common sense kind of prevails there a little bit.
Okay.
But there are ways of doing it properly. It's all about documenting your file in a way to protect yourself. Because again, buyers, if they get in trouble, they can try to point a finger also.
Right. Right. Okay. How do you handle a transaction when there is a loan modification pending?
I've seen that several times. Maybe a seller is in a bad situation, a loan mod is pending, and we want to buy that house, and we want to control it, right?
Right.
So you can sign a contract, and I get that, and sometimes we can go further. Now, if we as an investor are buying the home from a seller, sometimes I like to use an executory contract for deed, and maybe even record it in deed records with an understanding in that document that says once the loan modification is completed, the parties agree to go ahead and execute the full mortgage package. That could be done. I'm not really a fan of selling a home to a home buyer that way, because that's a different ballgame, a consumer transaction as opposed to a commercial transaction. But could we do that? Possibly.
Okay.
I kind of prefer to sign a contract with the buyer, maybe sign a lease, where we have an agreement that once the loan modification is completed, that we agree to execute the paperwork and close the deal. And in this interim time frame where they're paying rent for 2 or 3 months maybe, that gets applied to their mortgages if they're making a mortgage payment.
Okay. I know in so many times when we go on, especially foreclosures, they'll all say, well, I've applied for a loan mod, it's pending. But it never happens. They get dragged down the road, and then at the last minute, the bank doesn't grant.
Right. Well, that's a different scenario where there's going to be more arrearages for us to buy and consider if we're dealing with that. There are various situations, though, where loan mods do actually go through, and there's been paperwork executed by the bank. And if you've got the paperwork and it's been executed by all the parties, it tells you there's one in motion. If you don't, it's just lip service until such time as you do.
Okay. Okay, here's one for you. Husband and wife are getting a divorce and they want to sell the house. What do we need to do as investors? What questions do we have to ask? What do we need to understand?
Well, I think the first one is that they still own the house. They both own the home. And so they both need to act as a seller. And it's going to take both parties to do it. And sometimes it's not that easy. Sometimes one party or the other want to hold the other hostage, right?
Right.
You know, one will say, I don't care. We're going to let the house get foreclosed on. I'm going to do that on purpose. And so what we've got to do is do our best to get both signatures and get the approval process at closing to this happen. But it doesn't always work. I've had some situations where I've actually gone in, bought half the property from one of the spouses. Maybe I brought the loan current if there were some arrearages, so foreclosure wasn't pending. And maybe I can negotiate better than the other spouse because I've gotten the personalities out of it. But maybe I've got to go a step further, and some things we do from a legal perspective, we might file what's called a partition suit, which becomes a forced sale, a little bit more complicated, more expensive. And if I foresee that being an issue, of course, I've got to make sure I buy the house for less money to help offset some of that cost and expense. But the whole key there is realizing you got to have both parties, not just one.
Would you ever sell yours back to the other spouse? You bought half the house. She doesn't want to sell, she wants to live there. You could sell it back to her?
Maybe. It could be a possibility based on their abilities.
Okay. Okay. A buyer wants to buy the house in their personal name.
Okay.
But they may be married. What do you do about that? They don't want the wife on there.
Okay, so the husband wants to buy the house. And, you know, again, if you're in a community property state, maybe they want to buy it as their sole and separate property. And I find that interesting because so many people don't understand that if a husband and wife buy a home, and even though the husband buys it in his own name, because we are community property, it's still going to be owned 50-50. There may only be financial liability to the husband on the note, but if there is a marriage and one party is buying it and the mortgage company knows about it, they're going to require this wife to execute the deed of trust no matter what.
Okay.
So I can see where the deed may go into the husband's name only, the note may be in the husband's name only, and the deed of trust or the security instrument is in both their names. But even though the deed is in the husband's name only, since they're married and they bought the home, it's still going to be community property. Unless one of the spouses is using sole and separate verifiable income to buy the property with, qualifies for it, they don't live in this home, they use it, one of them uses it as rental property, and they learn how to keep everything 100% separate to maintain the true nature of the separate property. And I find most people don't have a clue how to do that.
Right.
They're always going to commingle assets and funds, and they start to lose that aspect.
Okay, so what if they're not married, but they're common law married, they've been living together for a long time?
Same thing, only different.
What's different?
Nothing.
Oh.
It's just that it may not have a...
So say a guy owns a home, he's lived in it a couple years, he gets a girlfriend, she moves in, they're together for 5 years. Does she now own half that house he's been paying on?
Again, it depends if she files for a divorce or not, number one.
But they're not married, they're common law.
Well, you can be common law and still get divorced.
Really?
And if you're declared to be common law, then the divorce court is going to determine the aspect of that property in that scenario, I think.
Interesting. Okay. That wraps it up. That's all we got for today.